Welcome to Part 1, Understanding President Trump's DEI Executive Orders. Well, in his first week in office, President Trump signed 4 executive orders that directly address diversity issues and DEI programs. Now, we're going to take a look to see what these executive orders do, and 2 of them in particular. The first one is going to be Executive Order 14151, which is called Ending Radical and Wasteful Government DEI Programs and Preferencing. We'll see what that does. And then we'll look at Executive Order 14173. And that one is entitled Reforming the Federal Hiring Process and Restoring Merit to Government Service. All right. Now, I just want to make clear, whether you agree or disagree with DEI programs getting canceled is irrelevant. This is a done deal. It doesn't matter what I think, doesn't matter what you think. This is what is happening in your world. So as DEI people, as business owners, as HR people, you gotta understand what's happening and you gotta comply. Well, the first executive order is 14151, and it was signed on January 20th, 2025. And again, it's called the Radical and Wasteful Government DEI Programs and Preferencing Executive Order. So if you look at your handout here that I've posted for you, the first thing it does is it cancels DEI across the entire federal system. Now, what's that mean? Anything that even smells like diversity, equity, inclusion, environmental justice, accessibility, which we're talking accessibility not for disability, but for all these, DEI type programs. All right. So whatever you're calling it, if you are in the federal government, if you're an employee, those programs are gone. That is the power of an executive order. That's the power of the President of the United States. All right, now let's just look and make sure we all understand what an executive order is. This is something that the President can put out there that controls the federal government, all 3 million plus employees, all right, all the agencies, everything. They all report to him. He is the CEO, all right? But this also is something that he can order to put into the contracts. All right, so if you are a government contractor, and this is for you on page 2, all right, you have to affirm that you are going to comply with all federal anti-discrimination laws, okay? And you also have to attest that you're not promoting DEI in any form at all. All right, so this gets into a couple of things here. First of all, it says that you are going to be in full compliance. So you're a government contractor, and if you want the government's money, now those are for grants, loans, direct contracts for services or products, all that's covered. And if you want to keep doing business with the federal government, you've got to adopt this. All right, now that means that your DEI and anything smells like it has to be taken out and blown up. Blown up, all right? This is not an attempt to reform DEI. And just to sort of fill you in, I have been trying to reform DEI for decades. And most importantly, across the last 2 or 3 years, trying to tell associations and SHRM chapters and all this stuff, what you're teaching is illegal. Okay? You are also stereotyping all white people as this, all white people. And understand, this is coming from some of the top DEI folks in the country. All right? Like Kendi, like Robin DiAngelo, where you will get them to say that, well, if you're white and you're in this country, you're a racist. All white people are racist. Okay. This is the pendulum swinging back to the right, and it's canceled. All right, so I've tried to reform it, but I'll tell you right now, there's no reforming anything. This house has been burned down. Because here's the other thing about government contracts. All right, first and foremost, let me give you an example of when I was working at a company called Combi Block. All right, we were a German juice company, or juice box company, and we made aseptic juice packaging for Smucker's jelly. All right, so Smucker's is a direct contractor with the federal government. They supply millions of dollars in jelly to the federal government. All right, we were not a government contractor, but Smucker's was directed to put into all of its contracts that its contractors had to comply with the executive orders, and the executive orders of the day, that was affirmative action. So even though we didn't do any business with the federal government, Smucker's was forced to put into their contract that we were going to comply. So we had to have an affirmative action plan, even though we didn't do any business with the government. So you need to think of this like Guardians of the Galaxy, Groot. All right, Groot's fingers are going to grow out and going to encompass all federal employees. They're going to grow further, and they're going to go get all of the government contractors. And depending on your contract, those fingers could go even further and get you if you do any business at all with the federal government. So the president's fingers are long. They really reach across this entire country. So millions and millions and millions of nonprofit, private, state, government, local, whatever, they are all going to have to comply with this. So that's the first thing. All right. Another thing to think about is a lot of organizations have started doing what we call rainbowing. What's that? It means, we kind of think the federal government is kind of stupid. So what we're going to do is we're just going to change the name. We're going to keep the same DEI practices that we've always done in the past, but we don't think they'll ever figure it out. Well, that was University of Colorado. All right. They changed their name from DEI to the Office of Collaboration. That isn't fooling anybody. That's not fooling anybody. Because here's the big rub. In all these contracts, it says that this is a material aspect of this contract, which means it's important. If you violate it, you have made a false claim to the federal government, and that falls under the False Claims Act. So guess what? The federal government can come after you and get triple damages. Yes, triple. Oh, you do not want to go down this road. You will be toast before you hit the ground. All right? So you do not want to violate these. And of course, this is applying to all those contracts you've got right now, all of those loans you've got right now, all of those grants you've got right now, and this is what is happening as we speak. All right. Now let's say that you have nothing even close to a federal contract or a contract with a federal contractor or any of that stuff. There is a very specific warning to the private sector that we are going to come after you. We are going to come after you. So if you are in the private sector and the executive orders fingers do not reach to you, well, we're going to put you on notice anyway, because the president controls the EEOC. The president controls the Department of Justice. And I'll tell you, now that this stuff is out there in the wind, My Legal Update had a whole section, and I will post this on my website, a whole section on DEI claims against employers. And we typically refer to this as reverse discrimination, but there's really no reverse to it. White people, black people, Hispanic people, Asian people, those are all protected classes. And the United States Supreme Court in 2024 ruled that You cannot treat people differently. You can't treat someone worse because of their protected class. Now understand, that is a huge change in the law. It used to be that if you were going to treat your women different than your men, or your Asians different than blacks, than whites, than the Muslims, than the Christians, it had to be a substantial or significant difference. That's what the law said before 2024. The United States Supreme Court changed that. They changed it. So guess what? If you treat anyone worse because of their protected class, you've just violated Title VII. So yes, you're going to see Title VII claims boom. Well, that's what Executive Order 14151 did, and it gets worse. All right, so now let's turn our attention to Executive Order 14173, and that is reforming the federal hiring process and restoring merit to government service. Okay, that was signed into effect on January 21st, 2025. All right, what would this do? Well, first and foremost, it took affirmative action out into the backyard and blew it up. Yes, affirmative action from the federal government is dead. It's done. Okay, now, let's make sure we understand what affirmative action was really kind of supposed to be under Johnson. Because President Johnson, decades and decades and decades ago, when I was just a little boy, signed this affirmative action into place. And what it says is, okay, you've got to go out and look at the last census, which back then was 1960. You got to go look at the last census numbers. And your workforce has to reflect what your workforce in your area looks like. That's what you got to do. You've got to go and do this big analysis from the 1960 census. How many black noses live in your area? How many female noses? How many Hispanic noses? How many Pacific Islander? On and on and on and on. And here's the logic. If I've got 100 marbles in a jar, and let's just look at the stats for how many white people and black people there are in the United States. Well, there's 76 marbles in there that are white. There are 13 marbles in there that are black. Maybe 6 or 7 marbles in there that are brown, and then you got some other ones just all mixed in there. So we're now going to have this jar, mix them all together. All right, so what is happening? Well, it's like 1963, 1964, 1965. If I reach into that jar and I grab a handful of marbles, what are the chances that they're all going to be white? Well, in Columbus, Ohio, the chances are really slim and none, okay, because that's what was happening. And understand the reasoning for these types of laws and these types of executive orders. 1959, I want you to get this and how embarrassing Jim Crow was. All right, Jim Crow apartheid laws here in the United States, which means you can't buy a house in this area, redlining. I could refuse to hire you because you were white, or I could refuse to hire you because you were black. Okay, very few people refusing to hire you because you were white. Okay, 1959. Listen, folks. In 1959, 55% of all of the black people in this country lived at or below the poverty line. Okay, you hearing me? Whoa. That is more than half of every black family in this country living in poverty. And what that mean? It meant you're hungry. It means you're cold. It means there is no money for education. It meant you are doomed. Okay? Gandhi said the worst form of violence you could inflict upon another human being is poverty. And he was right. Now, what effect did Title VII in 1964 give us? All these other civil rights laws across the country. What did all this do? In 2023, we collectively brought that poverty level down amongst black families to 15%. Yes, it's dropped 40%. Now, I'll be the first to tell you we're not there. And I'll be the first to tell you, if somebody is standing in front of you and they are hungry, they are cold, they are homeless, if you care about the race of that person, you're a racist. And I don't care what your color is. A person is equal to a person is equal to a person. And it's all of us collectively to make sure that it gets better for everyone. Okay, that's what affirmative action was supposed to do. You were supposed to reflect the numbers of your community. What it has turned into, and a lot of you have attested to this, is it has turned into preferential hiring. That's not what it was intended to do. And that is what it is doing today. All right, so no, this came up in our discussion. Well, what do we do with our diversity statements and our EEO statements? Well, you see, your EEO statement says that you are not going to break the law. And what are they referring to? They're referring to Title VII. That means you are not going to give preferential treatment. That means in hiring. That means in setting up mentoring programs. That means in promotions. That means in training. You are not going to give preference to anyone because of their protected class. All right, that's what that means. So your EEO statements should remain intact. Those have been effective since 1964, and they're still effective. Your diversity statement, on the other hand, you've got to go and you've got to look at those, and you've got to make sure that you're not using any type of language that is referring to equity, to diversity, to DEI, to inclusion, to belonging, and all these other types of things. Those are lightning words right now. Those are lightning words. Okay, so affirmative action is dead. And some of you, I've gotten a lot of questions. Well, we still have an affirmative action clause in our contract. Contact the federal agency, contact the Attorney General's office of your state, contact somebody, because I will tell you right now, the government just has not had a chance to address all these contracts. You understand, there are tens of millions of contracts out there that have been affected by this. So no, affirmative action, as far as the federal level is concerned, is done. And some states, I am told, have affirmative action, and so you're going to have to check with them, because chances are really good that the state is enforcing affirmative action from the federal government. Okay, so affirmative action is dead. All right, whatever its original intention, doesn't make any difference. This is what the president has signed in, and affirmative action is an executive order, and so President Trump has overturned President Johnson's executive order from the 1960s. Okay, now again, also federal contracts. Your federal contracts are absolutely positively going to include a ban on anything that looks, smells, tastes like DEI. All right, and they're going to be looking for those weasel words. They're going to be looking for all those words that are now electric and third rail stuff. So you got to make sure you're not using any of those. But more importantly, you got to go and make sure that your handbook, your policies, and everything else, that you don't have illegal tactics in there. And a lot of the things that we've all been doing for the last 20 years are in fact illegal. Okay, so you got to make sure you understand the law. All right, now here's where it gets really interesting for private employers. An even stronger mandate from the president, and Andrea Lucas, who is the acting chair for the Equal Employment Opportunity Commission, has said that we are going to strictly enforce Title VII. And this gets back to a great interaction that she had sort of digitally with Mark Cuban. Mark Cuban was in front of Congress testifying on DEI. And Mark Cuban got up and said, you know, DEI, diversity, is a business advantage. If it's better for me to hire someone who is black or someone who is a female for a particular job, I'm going to do it because it's good for business. All right. The senators stopped him immediately because the senators apparently did know the law and he didn't. And they said, you need to be quiet right now. You should not talk anymore. You should never say another word. And you need a lawyer. Because what you are saying is illegal. And I'll tell you, just this week, all right, right here in February, the week of Valentine's Day, the 14th, the New York Times ran an article that said, what is illegal about DEI? You see, this is the problem, folks. We got people teaching DEI and they don't know the law. It's illegal to base any employment decision on any aspect of your job at all, any tangible benefit, based on race. Any protected class. Andrea Lucas came out and boy, she just blasted Mark Cuban. And understand, Mark Cuban is probably there with the best of intention. He's saying, hey, I'm going to give preference. And she said, no. Mark Cuban is violating the black letter of the law. And it is critical that he understands and other people understand that if race or religion or gender is any part of the decision, that's illegal. And so she is saying, private sector, we're coming after you. We are coming after you. All right, so I'll tell you, there are law firms all over this country that are popping up. And they are saying point blank, hey, we're going to come after you. We're going to come after you. And understand, part of this False Claims Act, if you attest in your contract that you are not engaging in DEI and you do, you see, an employee can turn you in for that. And an employee can maybe recover 15 to 30% of the award. Yes, your people are going to rat you out faster than you can even think. All right? And there are these law firms all over the country who now specialize in suing employers who engage in DEI practices. So I tell you right now, these arms are long. You've got to understand what these executive orders are doing. All right, so what do you do now? All right, now here let's get to the meat of it. First and foremost, go and educate yourself. Go and learn what is legal and what is illegal. And I'll tell you, I've spoken at 25 DEI conferences and always profess this. All right, I have never been to a DEI conference, whether as a speaker or an attendee, where I didn't have some speaker get up and profess illegal tactics. No, you gotta know the law. Understand that the affirmative action or the equal employment opportunity statement, your EEO statement, typically conflicts with your diversity statement, because your diversity statement says that you're going to, maybe give preference to this, or you are going to do something. All right, and you've got to look through all of your stuff, make sure that that isn't there. Conduct a complete and full audit to see, are there any illegal tactics hiding in any of your practices? Such as, hey, I really would prefer if this next person was black. And let me tell you, I see this all the time. I experience it all the time. I mean, I've got a best-selling book on tolerance and diversity. And so I get a lot of calls from my clients. They say, oh, yeah, I know, we'd love to have you come in here and teach this, but our board has told us that we need somebody who's black. And I'll tell you, I have had black employees where I am teaching this stand up and drop the F-bomb on me, call me white boy. I mean, I'll tell you right now, this seems to be acceptable bigotry, and you cannot have that in your organization, or you're licking the outlet. It's going to get you. It means you got to go look at your website, your policies, your handbook, your marketing materials, your training and mission statements. It's like looking for fleas. Go through with a fine-tooth comb and look at everything and get ready. You see, if you throw your DEI program out like Target did, you're going to get boycotted from the far left. If you keep it, you're going to get boycotted from the far right. We got to come to the middle, and we'll talk about what you need to do here next once you do your audit. So get ready for a communication plan. Make sure that you have things all worked out. Here's what we are doing, and let me just tip my hand. We are building a safe environment for all humans. All humans. All right, and we'll get more into that here in a minute. All right, examine these executive orders. Examine all of your contracts. Make sure you know what is being enforced against you. All right, make sure you know what's in those contracts. Yeah, you actually really should read your contracts. There's a novel idea. All right, now you want to make sure that you understand if you're receiving any money from the government at all. Okay, you are going to be at increased risk by the Attorney General's offices across this country. And those law firms are out there. And then finally, make sure, and you should have always been doing this, keep detailed records of your employment practices and decisions. Why did this person get to go to a certain conference? Why did this person get promoted? Why did this person get hired? Keep your records of hiring and recruitment. The performance evaluations. Oh, yes, yes. If your performance evaluations are not accurate, stop doing them. Stop doing them. No, because now you've got a performance appraisal in there where the supervisor is more than likely a passive aggressive and didn't really want to upset the employee, so we gave them a better review than what they really maybe deserved. No, they've got to be valid. Look at all your training materials and your attendance records and look to see what you need to do to change. Not just change the name, but actually change the way your DEI operates. Critical stuff. Now in part 2 of our program, we are going to look at the program you need to adopt that you're already doing to replace your DEI. And this is a program that is already in your organization. You just need to bring all of your anti-violence, bullying, harassment, safety, health and wellness programs all together to build a safe culture for all of your employees. And that is what we are going to talk about next. And of course, as always, if you have any questions on any of these types of issues or anything at all, please feel free to shoot me an email at scott@scottwarwick.com or give me a call at 614-738-8317. And of course, you can always go to my website, scottwarwick.com, where there is a wealth of information for you to go and take a look at.